Hello, this is Dane Ciolino, and welcome to our presentation on Introduction to Mind Manager and Mind Mapping. Now, we've talked before about how important it is to keep track of all of your information in your cases, your documents, your to-dos, your appointments, your people, issues, and whatnot. There are a number of ways that you can organize this information by using case management programs like CaseMap, using various practice management software, Clio, Rocket Matter, others. But eventually there will come a time, in most cases, where some event happens, where you have to show up and you have to perform. And by perform, I mean you have to give a speech, or you have to examine a witness, you have to make a persuasive argument to a court or to a panel of a hearing committee. And when that time comes, even if all of your information is meticulously organized in some case management software or in some other practice management system, you need something different to bring with you to that event so that you can be prepared. Well, in this regard, what are your needs? What is it that is driving this preparation for, and we'll just call it the event? Well, the first need is that you want to build both the facade and the structure of a logical presentation. By facade and structure, I mean you want your presentation to look like it's logical, but it also needs to be logical. Why? Well, this takes us back thousands of years, really, to Aristotle, and Aristotle's still persuasive today and still very relevant today work on rhetoric. Aristotle said that there were really three different elements of a persuasive presentation. There was logos, or logic, ethos, or the personal advocacy and credibility of the speaker, and pathos, the emotional aspect of the speech. Well, by having a speech or an argument that is logical and that it stands on its own logic and also makes you appear someone who is logical, you are building up both the logos and the ethos in your speech. So that's one of your critical needs. You want to look prepared, you want to have an argument that looks logical, and you want it to be logical, and you want actually to be prepared. Now, there are some people who are meticulously prepared, but then they stand up and they look like they're just bumbling around. There are people who look like they know what they're talking about, but when the court or the witness throws a curveball at them, so to speak, then they are completely at a loss. Those people have either one or the other of these attributes. That is, they either appear to be knowing what they're talking about without having that underlying structure, or they have the underlying structure without being able to prove it or show it. You need both. You also need to be, this sounds a little bit contradictory, you want to be both well prepared and spontaneous. One of the leading books on public speaking that you can buy by an author named Brian Johnson is, and the book is called The Articulate Attorney. Excellent book. I think really the best single source on public speaking for lawyers. And what he says is that you want to strive for structured improvisation. By structured improvisation, I mean you want to have structure to your talk, but the audience doesn't want to believe that you're just reading the talk. If you're just reading it to them rather than speaking with them, you are going to be a far less persuasive speaker. So it's critically important for you to be both well prepared and spontaneous. The spontaneity matters because it's much easier to listen to someone when they're speaking kind of from the heart or off the cuff than from a prepared speech. And you don't want to be that person. But then again, you want to be well prepared because you don't want to be up there just babbling around because nobody wants to hear that either. So you have those two seemingly contradictory needs, but they're not really contradictory. And then finally, and perhaps even most importantly, is you want to have your facts and your law at the ready. That is, you need to have whatever the factual material and information is that you need for your examination, whether it's facts that are contained in documents or facts that come from other witnesses, and the law if you're making an argument where legal issues predominate or are important, where you need to know what that case held or what the legislative history of this statute was. You need to have all that at the ready because you need to not just tell the judge or the finder of fact what the facts are or what the law is, you need to show them what it is. Quotes from cases, quotes from witnesses. And if you get follow-up questions, you need to show that there's some depth to what it is that you're arguing in your knowledge of the topic. So you need to have the facts and the law at the ready. These three things are what is driving, in my view, the need for some highly particularized organization of information at an event. Well, this would be one way to organize information. If you're getting ready to go up to a podium and give a speech or question a witness, you can bring some combination of hand-scribbled, typewritten documents that are contained partly in file folders, partly in expandable folders. That would be one way to do it. A lot of lawyers get by, particularly older lawyers, manage to do quite well sometimes with this sort of haphazard approach to event preparation. Most of us, however, can't get by like this. And I would suggest, since you're kind of trying to rethink the way that you organize information, you want to not start by organizing information in this format, but use something different. Well, what are some of those possibilities? Well, solution one, rather than the handwritten, scribbled narrative notes that you might bring up to the podium, would be bullet list. Now, a bullet list, we've all seen bullet lists, you know what they look like. A bullet list has various points. Point 1, point 2. The nice thing about bullet lists, there are several improvements over the narrative notes when you decide to use bullet lists. And one of these is that you are forced to chunk your information. On a bullet list, you can't write long narratives. You have to condense the information to easily bite-sized chunks. And of course, if you're going to eat a steak, you're not going to eat it by eating the whole steak. You're going to eat bite-sized chunks of the steak. And that's what you are striving for here when you are doing your bullet list. You want to make the information in a format that is easily digestible. Well, bullet lists are good for that. They're also good for structural improvisation. Why? Because if you can't handwrite out or type out the whole narrative, but only the essential information necessary to jog your memory, then you can't read it. You can't just read point 1, point 2. You have to draw on your memory and use that to improvise. But the improvisation would be somewhat structured by the fact that you're using points and bullets. Well, despite the improvements that bullets give you over narrative, handwritten, or typewritten notes, you can do better. And that better would be by using a linear outline. Now, a linear outline, you all know what these look like. We use them in law school. It is bite-sized chunks of information, but the bite-sized chunks are arranged hierarchically. Point 1, point 2, subpoints, we're under those points. It brings with it all of the benefits that we've just discussed for the bullets, but it also brings something new and some additional improvements. And that improvement comes from the hierarchy. By hierarchy, I mean the subpoints and the sub-subpoints below points. Why is the hierarchy good? Well, the hierarchy is good because, first of all, it forces you to think rigorously about your topic. If you have 4 points to make, then when you want to make another point, you have to determine whether logically it's a sub-point under one of those 4 points or whether it's its own standalone 5th point. Now, all of that is very important because it does kind of lead you to think about whether you need to, how you need to organize this information. Now, linear point outlines are good, but you can and you should do better than linear outlines. The problem with them is that they're multi-page documents, and when you're standing up at a podium, you don't have a lot of time to be flipping through pages. They also are full of, they can tend sometimes to become long and narrative. The worst part about them, the worst point that I can make about them is that they are not graphical. We, most of us, are visual learners, and we do better with pictures than we do with words. And that's where mind mapping comes in. Now, what is a mind map? Well, here's an example. This is a mind map that I prepared some years ago to help first-year law students think about how to organize a case brief. Now, you can see it shares, at least on a high level, some of the basic attributes of a hierarchical outline. Why? It's got hierarchy, right? It's got major points, it's got minor points, and minor, even further points under those minor points. So it's hierarchical. But what it brings something that's visually interesting, and that brings additional ways to distinguish bits of information from other bits of information. You can use color, you can use imagery, and this mind map that you're looking at really uses both. It doesn't use images the way that I think a really good mind map does, but it's a start. And that's what we're here thinking about in our first discussion of what a mind map would look like for lawyers. So you can see how this information is organized hierarchically. If you look at the background up there, you've got the name of the case, the parties, the factual circumstances behind the accident, the claims that the plaintiff has made against the defendant, and what the defendant claims by way of the defense. We've got some of the background, the procedural background by what happened in the trial court. Then we have, move along, since this is a case brief, to the case brief itself, the holding, the issue, the holding, and what the judgment was, and then the court's reasoning. You can see how this would be useful to a first-year law student who got called on, and the event for that student would be getting called on and responding to the instructor's questions. How might the student do that? Well, the student can look down here and answer whatever the questions posed by the instructor would be. If the instructor is asking about the facts of the procedural history, or what happened in the lower court, what the court's reasoning was, all of that's readily available on a quick look from this mind map. All right, so mind maps are better than, certainly better than long narratives. They're better than bullets. They're better than hierarchical linear outlines. Let's now talk about, first of all, the why. So mind mapping theory. Why is it that mind maps are better for learning and organizing and presenting information than the alternatives? Well, first of all, as I've already said, we are, most of us, visual learners. We learn better when we see rather than when we hear or touch or smell. So any information that you can see from your standpoint, or show from your standpoint as a presenter, is going to resonate better with the intended recipient. So mind mapping is very visual. Mind mapping uses hierarchical organization. This principle of hierarchy is one that is kind of universally understood to be the best way to organize complex information, at least complex information ideas. I'm not talking about complex information about kind of grades of of members of a class, or the heights of the tallest trees, or the weights of the biggest beetles in the forest. But when we're talking about organizing ideas, and that's what we do as lawyers, we organize and present ideas, hierarchical organization is the best. Well, mind mapping forces hierarchy. You have got to put the information somewhere on that mind map on some branch. So you immediately are forced into that rigorous thinking of deciding, what does this information relate to, what bigger issues in the case, and what major branch should I hang this information on. Again, all of that forces you to think logically, and will, when it's time to present, force you to present logically. Finally, it's minimalistic. Doesn't take a lot of time to do. Now, I know that sounds kind of odd to say, because this is new, and anything new takes a lot of time. No doubt about that. No doubt the first time that I started using mind mapping programs on the computer, that it took much longer to do it the first time, and maybe the first dozen times, than it would have been to do it the way that I used to do it. Now, that's probably true of any new way of doing anything. Anytime you are going to change the way that you do things, it's going to take time. It's going to be hard. Well, once you learn how to do it, this is the good thing, is that you can sit down and very quickly, because you're just putting down a minimal amount of information, just the big chunks of information, and you're putting down in hierarchical format, you can do a mind dump or an information dump, and very quickly put together the information in a logical format that you're going to need for the event, as we can call it, whatever the event is. Okay. Now, you can do mind mapping by hand, and when I first started mind mapping is when I was studying for the Louisiana bar, maybe even the New York bar, back in 1988. And I had large pieces of paper. It wasn't butcher paper, but it was, I think, probably 11 by 17 paper. And I would draw out with pencils, and I called them flowcharts at the time, all the information I was studying. For me, I couldn't study without flowcharting because I would daydream. But you can do this by hand, and if you are good artistically, then this might be a preferable way for you to do it. You can draw more, you can connect personally more with the information, so sometimes it is better. But the problem with doing it by hand is you can't easily go back and rearrange and add and delete information, because once it's on your piece of paper, of course, if you do it with an eraser, you can erase, but you can't elegantly add new information or move around what you have there. That's the beauty of the mind mapping program, software, is you're able to do it all electronically. Now, what I have on the screen here is a program called Mind Manager. Mind Manager is just one of, no doubt, dozens of mind mapping software programs that are available for download or online use, cloud use, on the web. This is the one that I've used. It's really one of the first ones, one of the leaders. It's expensive. They used to have an academic price. They still may for students. But it is cross-platform. It works on Windows, on Mac. It does work on iPads and iPhones, though I don't particularly like the way those applications work. But they do have the capability to work in other platforms. I would suggest that you download Mind Manager as a free trial product. I would suggest that you download it now and start playing around with it. You may decide that you want to use another mind mapping program. I'm not going to force Mind Manager on you. If you would like to try something else, you can. Just go on Google. You can find one. I think iThoughts HD is one for the iPad that is some people use. There are others. Again, I'm a mind mapper with Mind Manager, so this is all I use. Anyway, what does the program do and where you get it? Well, you get it at www.mindjet.com. As you can see, this is a screenshot that I took of my screen just a few minutes ago. You can try it free for 30 days. No credit card is required. So please go download it. All right, well, what does the basic screen look like? This is what the basic screen looks like. Not much to it, right? All mind maps start out with just a single central topic. So, for example, if I'm going to do a witness outline of John Smith, my central topic would be cross X of John Smith. From that come what are called topics or subtopics. First topics are the major topics, and then subtopics. The program also has all sorts of other functionality that, for example, you can see it can have icon markers, text markers. You can put in hyperlinks, notes, images, all sorts of stuff can go in here. And there are map parts and libraries. Very powerful program, much more powerful than just what it would appear on first glance. The important thing for you, though, early on is to understand how to use this first as just a basic tool for hierarchically organizing information. And then start adding in icon markers, attachments, images. But this is basically the way it looks. And then you would add main topics. You can add floating topics, although I don't recommend that because you don't want to be floating around. You want to be grounded in your central topic virtually all the time. You can have call-outs. You can show the relationship between various different topics, main topics and subtopics. You can use boundaries around the topics. And again, these are tools that I use routinely. I mean, you always are going to use topics and subtopics, but I routinely will use the relationship arrows to show how information relates to one another. I'll routinely use boundaries to set off particularly important information that I need to find very quickly. So, and notes, I will often use notes. Notes gives you the ability to kind of behind the layer of the topic to add information about a particular detailed narrative information about a particular topic or subtopic. Like, for example, what will I use a note for? If I've got an argument and I want to quote from a case, I'll have the case and I'll have not bullet pointed, but I'll have the subtopics, the main points that the case makes. But if I have a quote that I'd like to read, I'll have that buried in a note. So I can just double click on the note, read the narrative, and then get back on task by going through my topics and my main topics. Now, again, you can also hyperlink, as you can see here, to websites. You can attach documents. You can hyperlink to documents, and more on this shortly, but you can hyperlink to documents on your particular computer, and also embed them in the document if you prefer to do it that way by way of using attachments. You can also, as we've already said, use markers to highlight and flag information. These are things that I use routinely. Now, like any program, and I hate to say this again because I've already said it once, and I'm going to continue to say it over and over and over again. That's just the nature of this learning. The only way to learn how to use this program is to download it, put it on your computer, and fool around with it. Make mind maps. When you get frustrated, figure it out. Go to the help, and this is the help functionality that's in Mind Manager, MindJet for Windows. Again, very, very useful information, and just kind of use this as an excuse to teach yourself how to use this program. Okay, well, remember, organizing a case kind of starts with getting the facts, researching them, gathering them, getting them through discovery. Then you organize them and kind of arrange them in a way that is logical. And then you got to stand up and you got to tell your story. And this is really what we're talking about here. How is it that you can use Mind Manager later in the game, closer to the event, in order to get yourself ready for that event, that witness examination, that hearing, that trial? Well, that's what we're going to turn to now. Think, for example, of what you might do in cross-examining a witness. Cross-examination is, if you want to use kind of the traditional format that Irving Younger has suggested, is usually about two things. Of course, now, it could be about other things, like, for example, you could be cross-examining a witness who's a relatively friendly witness, or even if not, a witness who has helpful information. And then you just ask the witness the questions, of course in a leading fashion, but you ask the witness questions in a way that is just going to elicit the information, the substantive information that you want. That's not that much different from direct, except for you're going to use leading questions rather than open-ended questions. But usually if this is a witness who you want to discredit, you're going to discredit the witness using or on two fronts. First of all, on the elements of competency, or perhaps by impeachment. And by impeachment, of course, we are using things like showing the jury that this person has made is basically unworthy of belief. Now, when you've got good impeachment, this is the funnest cross-examination there is. You're essentially showing the jurors through your impeachment that the witness is not worthy of belief. Why is the witness not worthy of belief? Well, one, it could be that the witness has made prior inconsistent statements. Two, it could be that the witness has some kind of motive to deceive. Three, it could be that the witness has prior convictions, or has done prior bad acts, or just kind of has bad character. But whatever you're doing, you are going to want to do it in a way that is sensible. Now, this mind map really is one that I have on my computer, and as goofy as it sounds, anytime I sit down to prepare for a cross-examination of a witness, I look at it. And I ask myself whether I have any of these, almost kind of in a checklist fashion, whether or not any of these avenues of cross-examination might be useful in this particular case. Now, the other general area is elements of competency. Now, the goal here is not to show the jurors that this person is a liar, though they may be, but just to show that they, for whatever reason, aren't competent to testify. That is, because they don't understand the oath. Now, this almost never happens. What most often this kind of examination is about is perception. The witness didn't see what she thought she saw or hear what he thought he heard. Why? Because they were environmental circumstances. It was too dark. The witness didn't have their glasses. Maybe the witness can't remember because this happened a long time ago, or they're old, or they just saw too many people to remember that this person happened to be a hotel guest. The point of this mind map is that you can use these mind maps as an example, kind of as a checklist of the things that you might want to do. Now, here is, for example, one of the, this is a cross-examination that you might, for example, use in a case where it's an eyewitness identification case. If I was going to stand up and I was going to cross-examine a witness in a case, this is all I bring up to the podium with me. I wouldn't bring a yellow paper all kind of dog-eared and handwritten. I would bring a mind map like this. I would either bring a paper version of it, that's what I usually do in the past, but now, increasingly, I walk up to the podium with my computer and I flap open the top of the screen, and then I use that to do my examination. So how might this examination from this go? Well, generally you're going to start up at the top and you're going to go in clockwise direction like this. Now here we only have two major branches, so it's easy. We're going to start here with this, or at least that's my initial plan, and then I'm going to finish with impeachment. Now the nice thing about this is that on direct, I'm going to go up to the podium with my computer. I can be moving things around, I can be eliminating areas of cross-examination all on the fly. Something that's very nice about using a computer to do this. If I were to stand up, I would stand up and start talking about or asking the witness questions about her ability to perceive. Now, what I do here in the kind of main body of the mind map is I put the answers that I want to get. Notice that you don't see a single question mark on here. Every now and again, I might want to ask an open-ended question, and I might remind myself to do that by putting a question mark. But usually I just put the answers that I want. The nice thing about just putting the answers is it's short, and it also causes you to improvise. If you write the question out, you're going to say, were you wearing your glasses? But if you want to point out that she wears glasses, you want to admit that, I would stand up, for example, and say, good afternoon, ma'am. My name is Dane Ciolino, and I'm an attorney for the defendant, and I have a couple of follow-up questions for you. First of all, I want to ask you about your ability to see what you thought you saw. And I'd like to start with glasses, eyeglasses. You wear eyeglasses? Yes, I do. Your eyeglasses broke the day before the robbery? Yes, they did. And they broke because you dropped them at work? Yes, I did drop them at work. Now, how do I know all this? Well, I know it all because I've learned it from a police report, or I've learned it from a deposition. You don't take in criminal cases, but I learned it in a motion hearing. So again, I'm just showing the jurors that I know the answers, and I'm getting her just to agree. And then you were not wearing your glasses at the time of the robbery because they were broken as a result of being dropped at work the day before. Yes. I now want to ask you about the lighting. This robbery occurred at 10 p.m. Yes, it did. There was no street light at the corner where this robbery happened, was there? No, there was not. And when you talked to the police shortly after being on the scene, you told the police it was dark. Yes, I did. Now, you just testified here today that you were able to see the robber, right? Yes. And you say that the robber was my client, Mr. Defendant. Yes. But you gave the police a statement right after the robbery, didn't you? Yes, I did. And in that statement, you told the police it was difficult to see the robber. Well, if she says yes, then that's fine, I'll move along. If not, she says no, I can pull out Exhibit 2 and I can go through impeaching her with her prior inconsistent statement. Now, impeachment, we've already discussed what that is. I don't need to go through this exercise with you again, but you can see how the mind map would just kind of lay out the major areas of impeachment. The answers to the question are here, not questions, and I could essentially, I might be able to cross-examine, depending on the way this examination went, for 15 minutes off this one page of paper. And I could do it in a way that would be logical, but also in a way that would be improvised. And of course, remember, those are two of your important needs when you're doing an event like a witness examination. Okay, so now how we've seen a way that you would use mind mapping for arguments, let's now, for witness examinations, let's talk about mind mapping for arguments. If you are going to stand up because you have an oral argument before the Louisiana Supreme Court, or you have an oral argument before the State Fourth Circuit, or before, as I often do, a panel of the disciplinary board. How might you do this? Well, you might, of course, stand up in your argument and bring crumpled notes and just wing it, but that wouldn't be very good, right? Because you would not have any structure. It would be all improvised, but you would not have any structure, and that's not what you want. What I would do is I would stand up. What I do is I would stand up with something like this. If I was doing a closing argument, the closing argument would be all laid out in a mind map. And what's the structure here? Well, as we've already said, you start basically here, and you go in clockwise direction, and you finish here. So you start here, and you finish here. Okay, well, what would I do, for example, here. Well, I'd stand up and very quickly do things like, thank you for your time. You took an oath to follow the law. I would then, if my feeling here was that the relevant law is that, again, I quote from the jury instructions, is reasonable doubt. That is, you have to acquit the defendant if there's any reasonable doubt as to his guilt. So the issue is not whether he did it, but whether there are any reasons to doubt that he did it. Are there reasons? Yeah. The witnesses weren't credible. They were inconsistent. Their testimony was conflicting. You heard evidence and saw how the police coerced the defendant's confession. No hard evidence, and a man with an impeccable career before this arrest. Now, I would then go through all of this, through the witnesses, through the confession that and this is actually a closing argument I used in a case that went to trial. Actually, went to trial twice. First case was mistrial. It was a postman who was prosecuted in federal court for stealing mail, and he confessed after 6.5 hours of interrogation when he was mentally tired, after getting promises of leniency, that they had threatened to search his house. But any case with a confession is very tough to deal with, but that's one of the critical things that we had to deal with in the closing. So anyway, these are, doing a closing off of a mind map is much better than doing a closing off of kind of a narrative script or even bullets or a hierarchical outline. Why? Because of the structured improvisation. Also, what I would do during the trial is I would keep this open in the background, and as I got information and I heard a witness say something during the trial that I wanted to include in my closing, I would switch quickly to that page and put it on there. Now, I'd have to reorganize it later, but I would have it there and be able to put it in a place that was a place where it belonged. Okay, so this is what a mind map for an argument might look like. Trial notebooks. Trial notebooks. Now, trial notebooks are, I remember hearing about these as a very young lawyer, about how every lawyer before going to trial needs a good trial notebook. And in fact, there are books on building trial notebooks, or at least they used to be. I can't imagine these books are still in print, but they might be, about how to build a trial notebook. Now, I would do this. The kinds of things you might put in a trial notebook, of course, would be things like, your to-do lists and your notes, and I would typically have that behind the first tab. You might have a case chronology. Now, of course, if I was using CaseMap, I would generate that chronology using CaseMap. You might have some kind of proof chart, that is how you're going to prove each element that you bear the burden of proving, or how you're going to prove each element of your defenses if you're the defendant. The order of trial, what witnesses you're going to call in what order. The motions that you have filed and perhaps the rulings on those motions. You would have your exhibits somewhere in your trial notebook. You would probably have your voir dire notes and papers and jury charts that you would use for voir dire. You would no doubt have something for your opening statement. You would have your witness outlines, your jury instructions, your closing argument. Some lawyers keep notes as to appeal. And one way to do all this is to keep all this information like this in, again, sticky notes, handwritten files, and whatnot. But that's obviously not the best way to do it. The way that I used to do it, when I used paper for this, was I would go online, I think the company was called BinderTech, and buy these trial notebook tabs. And the tabs would have all the sorts of things that you might want to have in a trial notebook. And they were very neat looking, they were colorful. They allowed you to start organizing your case early on with these tabs so you can find information. They had the tabs for civil cases and they had the tabs for criminal cases. And I became an obsessive trial notebook-er, if that's a word. I would even buy these very fancy looking barrister black or barrister gold binders to put to make my trial notebook. It was also nice because in cases in state court where long paper is used, the 8.5 by 14 rather than 8.5 by 11 paper, they would have binders that were 8.5 by 14, so you didn't have to fold or shrink down your documents. Again, it was wonderful when I was doing this. I would obsess over getting my notebooks to look good, to be well organized, because I thought that there was, of course, some end in itself to be organized for all the reasons we've talked about. But when you had your whole case at the ready in your nice-looking barrister black trial notebook, jury would look at you and think, you know what you're talking about. You're organized. And I think that helps. Of course, that helps with ethos and being a messenger that they would rather believe than the less organized messenger who's your opponent. And anyway, this is the way that I would use to do it. But I would do it using paper tabs, nice binders, but I'll do that. Now I use a digital trial notebook. I use a digital trial notebook prepared using MindManager and MindMapping. What might the digital trial notebook look like? Well, here's an example of what one might look like. Again, it says, In re John Doe hearing plan. I've got the name of the case up at the top right, and again, the goal here, of course, as we've already said, is to go in roughly clockwise direction. Now, having said that, you don't have to go in that direction, and really, you're not going in any direction. You're just organizing the information here. But I'd have general information with, kind of pending issues, my arguments, my opening. May not have the closing done yet, but I may have, a branch ready for it, so I can have it open, and I can make notes as we go along. Maybe issues to address. This all might change. Documents. Notice I've got a hyperlink here, so when I click on that, double click on that, it would open up over here, in a side pane. It would open up a list of all the documents in the case. So I can easily get my hands on exhibits, on rulings, and whatnot. Now here are some of the documents I would just list, like the formal charges in the case. Now notice that there is a hyperlink here to that document, which means that when I double click on that document, whether it's the formal charges or the answer to those formal charges, this is what you get. You get, well, you can really even see this. When you double click on it, you get the document itself to open up. All right, so on the answer, if I were to double click on that Acrobat answer, that icon, it would open up and it would allow me to see it. The brilliance of the digital trial notebook is that you can constantly keep it valuable, something that's more difficult to do at trial with a hard copy notebook. But it also allows you, particularly if you are a lawyer who organizes information digitally, to not have to print out information, to have all of your, for example, witness outlines and mind maps for witness examinations all done in one place and linkable. Again, it just makes it really a very easy, powerful way to organize information in advance of trial. Okay, well, what should you do? Well, I would strongly, as you would guess, suggest that you download MindManager, or if you don't want to use MindManager because you don't want to pay for it, find another alternative. You're not going to find one that's as good, but you can find others that work acceptably well, and start learning to mind map. Start off basically by using just basic branches and whatnot, but eventually you need to move into using more images, colors, boundaries, relationship arrows. Learn how to attach documents, learn to hyperlink documents and understand the difference between that. Learn how to view documents right in MindManager using its Acrobat viewer. Again, very powerful program, one that takes some time to learn, but it's time that is well spent for the power that you get to organize your information, have it at the ready, and then to use on your feet in a way that is persuasive. Okay, well, happy mind mapping, and we appreciate you listening.